salary and service of others, and thereafter they should notice that there is no continuance. So therefore,
No, you just come to para 3 of your application.
Minor.
The appellant came to know that in spite of the pending appeal, the school management, in the instance of another teacher, is taking steps.
Yes, my lord. For approval in my place, my lord.
How do we know what is there to show all this?
So is my lord, in this petitioner, this appellant was terminated. That is not termination. He was not allowed to serve as a teacher, my lord, by the headmaster. And the hostile animosity I have enclosed. There is an allegation.
No, extending the interim order, meaning the interim order is not continued, is it?
Because that is last occasion, the other side appeared. Respondent 4. He made a prayer by the proxy council.
Oh.
That is reflected in the order sheet.
I see.
Due to non-availability.
Oh, so the interim order.
Yeah, that is the
All right. You say the only limited extent of the prayer is that the interim order, which was earlier continuing.
Fine. The annex of 3.
No, which was made absolute on 28th March 2019
The next is
should be continued.
fine.
Paragraph, once an interim order is made absolute, there should be no need to continue it. In any event, it is clarified that during the pendency of the writ appeal, the interim order dated 28th March 2019 will continue. The application is disposed of.
Item number 2.
I mean, VC, my lord.
Yes, please.
Lord, your lordship may have a kind glance at page 32. That is the prayer made in the writ application, my lord. Then
Yes.
I come to the order. I am taking your lordship. Your lordship, has your lordship got it, my lord?
Yes.
Your lordship, see the prayer number 3, my lord.
Yes.
Real rule is calling upon the opposite parties to show cause as to why the impugned order dated 8/7/2021 under Annexure 8 issued by the opposite party number 2 and 3 and subsequently shall not be quashed, my lord. This is the prayer, my lord. Now, page 50, your lordship may kindly look at page 48, my lord. Annex.
Yes.
Has your lordship got it?
Yes.
This is the order dated 8/7/2021 by the Director General of Police, my lord.
Yes.
Lord, there the Director General Police, your lordship will kindly see, made an order that irrespective of the date of holding the supplementary exemption and passing of the supplementary exemption, they will be deemed to have been passed 5 years after the first exam.
Oh, I
That
see.
is antedating their promotion, passing of the test, my lord, to a period when they have not already appeared in the exemption. This was challenged, my lord. Your lordship may now see there are 2 prayers, my lord. One prayer was granted by the Honorable Single Judge, my lord. Another prayer, my lord. I'm a little bit baffled, my lord. Lordship may kindly look at page 143, my lord.
But tell me one thing, people who benefited by this order,
My lord,
those who benefited by that order, they were not made parties.
that was not the issue, my lord. That point was never decided, my lord.
Okay.
The Honorable Single Judge told that in case you have an individual grievance, then you file individual writ application and pursue a remedy with the appropriate authority, my lord. My lord, unless this order goes, it is a question of intercessionality. It is a question of whether the DGP has a power to make such an order in superstition of the order passed under Article 309 by the government, my lord. And second is that by a fiction, even assuming that the order is correct, by a fiction, my lord, how can somebody be directed to be deemed to have been promoted, even when he has not appeared in the examination. So these factors were not taken into consideration. One,
Notice has already gone in this appeal.
I don't know, I thought it has gone, but now I find that.
Yeah, notice has already issued on 31st March. 31st March. So the minute you say inter se seniority, parties, there will be some other individuals will be affected, sir.
That depends on the rules, my lord. Rule says that basing on the direct treatment of a particular year will be.
So can we clarify this? If you file another writ petition exclusively on the issue of inter se seniority, impleading those who are likely to be affected as parties, it will be considered on merits. It only means you file a second writ petition, that's all.
My lord, that's right, my lord.
Ah.
But unless it is
in the same writ, instead of in the same, because in this writ petition which has been disposed of, you've been granted partial relief.
Your lordship may kindly appreciate, it is not a question of individually claiming seniority over another person.
No, I'm saying assuming all of you want to jointly file a petition, you have to make affected parties, see, some has benefited by that order.
Your lordship will kindly see, madam, that is in relation to fourth batch, fifth batch, sixth batch.
No, so then successive.
Hundreds, my lord.
What do you do, sir? Somebody is bound to come to the court and say, without hearing me, the writ petition has been allowed, then now my seniority is affected. So in all these kind of inter se seniority matters, your clients are fully aware who is going to benefit and who is not.
My humble submission before your lordship is, since this is a matter of challenging the order of the DGP, if this goes, the consequences, they will work it out.
No. Those parties have to be heard, sir. See, usually what happens is, without the knowledge of some parties, in a writ petition between the state and the individual, some order is passed. It starts adversely affecting somebody else's seniority. That person is bound to come to the court and say, how come you did not make me a party, did not hear me?
Your lordship may kindly see the direction that it has directed that every individual has to file a writ.
No. We are clarifying, if all of you jointly want to file a petition, by all means file. But it has to be after impleading the persons who are likely to be affected. Let's make that very clear.
Then it will be constituted as a delay.
No. The very issue, when you call the issue as inter se seniority, it is 100% bound to affect somebody or the other who is not a party.
My lord, inter se seniority was never in dispute. Under the rules, we are granted seniority.
No. What you are now aggrieved in the writ appeal is, on the issue of inter se seniority, the single judge has said individually you should pursue.
Yes.
So on that issue, you say, no, why should we go individually? We come collectively. You come collectively, no problem. That is up to you, whether you want to come individually or collectively. What we are trying to tell you is, whenever you come like that in a substantive separate writ petition, you must make parties who are likely to be affected as respondents. It has to be under clear understanding that you will make the affected parties as parties to the writ petition.
Your lordship may give me that leave. And
yes.
Observe that
the limited grievance, all right. The limited grievance of the
another prayer that it will be because of the pendency of this writ appeal and writ application, it will not be constituted for delay and laches.
All right. You say the limited grievance in the present writ appeal that the learned single judge has while disposing of writ petition civil 20356 of 2021 by the impugned order dated 2/12/2021. Only granted partial relief as far as the right of as far as the petitioner's prayer to be considered for promotion from the post of sub-inspector to the post of inspector by reducing the eligibility from 10 years to 6 years instead of 6 years and 11 months. And that the other prayer in the writ petition, that is the challenge to the order dated 8 July 2021 regarding fixation of seniority has not been considered, full stop. It is noticed that the learned single judge has, as far as the issue of fixation of interstate seniority is concerned, open quotation, left it open to the parties who are aggrieved to agitate their grievance individually before the appropriate forum, comma, if he or she is so advised, full stop, unquote. Paragraph, Mr. Ashok Mohanty, learned senior counsel for the petitioners, states that the learned single judge ought to have dealt with the said issue instead of requiring each of the petitioners to individually agitate their grievance. Full stop. Paragraph, it is clarified the impugned order it is clarified that it will be open to the 8 appellants before this court to either individually or collectively file a separate substantive writ petition on the question of interstate seniority, but they will ensure that in such petition, the parties likely to be affected, if there of the appellants were to be granted, comma, are made opposite parties, full stop. It is further clarified that it will be it will be open to the appellants to contend in the writ petition, to explain in the writ petition any issue concerning laches on account of the pendency of the writ petition and the present appeal, and such explanation will be considered on its merits by the concerned court in accordance with law.
Stating that your lordship has dictated that agitate the issue of interstate seniority.
Yes.
Including challenge to the order.
All right, including challenge to the above order dated 8 July 2021. All right. All right. All right. The writ appeal is disposed of.
Item number 3.
Yes, had subitem and appearing, that in this matter, Senior Patnaik was arguing that, and he has some personal difficulty.
All right. It is stated that Mr. Patnaik, senior counsel, appearing for the appellant, is in some personal difficulty today. List on 16th February.
But the lordship looked at 2 writ appeal. One Mr. Roth is appearing, one Mr. Patnaik is appearing. But another writ application which is assigned to the single bench.
OJC.
Yes. The lordship direct that should be disposed of by the single bench within the meantime.
All right. You say as far as OJC, this order you put in 500 of 2016 and writ appeal 503. In OJC 54828 of 2002, list the roster bench of the learned single judge.
Yes.
On 17 January 2023.
Can it be a little bit earlier? Can it be a little bit earlier?
You don't know the pressure on that bench. That's why.
Because 2002 matter. Therefore.
All right. On 28th November. All right.
Obliged.
Obliged.
Ah.
So 2002. Let it be listed next Friday in sequence before your lords.
The assigned bench will mention it before the assigned bench, sir.
Because they about 300 people, one by one, dying. The other side.
So you mention it before that bench, sir. There is a bench assigned. Mentioning is before the assigned bench.
Supplemental list for admission. Item number 1, ARBP 65 of 2021.
My lord, I am for the petition. My lord, the fact of the case is a contract was awarded to the petitioner during November 2002 for construction of multipurpose cycling center. Petitioner executed the work as per the contractual provisions by September 2004. After execution of the contract, petition requested the authority to issue a completion certificate. Instead of completing, they issue the completion certificate, they took handover of the project. Accordingly, petitioner handed over the building on 8/2/2005. After that, they didn't issue the completion certificate till 2021. Finally, they issued the completion certificate on 5/7/2021. After, when I applied, I sought information under RTI stating that it is annexure 3 at page 47, my lord.
Mr. Rathi, this delay can be dealt with by the arbitrator.
In fact, I'll be citing three judgments, Lord. I have prepared a notes.
Ah.
Compilation of judgments, Lord.
All right.
I'll be citing your lordship judgment, Kamala Engineering, Lord. I'll be citing your lordship judgment, Kamala Engineering,
Let's see that.
Bidra Dolia and others, Lord. Kindly see, Lord. Lord, before that, would I request your lordship to just to see page 2 of my counter. Kindly see, I have given a very 5 dates only. Lord, as your lordship rightly says, delay can be subject matter there, but here is a case, it's a dead cause of action. The express on the cause of action is already dead.
No.
For 17 years.
Project was handed over,
Right, Lord.
but till the completion certificate is issued,
Right, Lord.
he can't raise a bill.
Lord, I'll just, Lord, that's a very novel Lord, method he has adopted. Kindly see the dates, Lord. Kindly
I
see
saw
the
the
dates.
date, yes.
Page 2 of my counter, kindly see
Right.
the date. The
Right.
sequence of events, I have only given 5 dates, my Lord.
That's right. 8/2/2005, entire project was handed over.
Lord, Lord, yes, a project was handed over 2005. Now the payment was made in the year 2004. Now, certificate, if your lordship kindly see, it's not the case of the company or the opposite parties to issue a completion certificate. Completion certificate as per clause 48, he has to apply for it and get it, my lord. Now he applies in the year 2021 and gets it 21, but 17 years after he applying. That's the point. Kindly see clause 48 of the contract. Lord, clause 48.
My lord, I have not applied for the completion certificate.
Mr. Panda, you have only on your application. Kindly see. Lord, page 39. Page 39.
Yes.
Clause 55.
Yes.
The contractor shall request the engineer to issue a certificate of completion, and the engineer will do so upon deciding the work is completed. Now, upon completion of the work, you have completed, handed over the site 2005, and you are applying for completion certificate in the year 2021 to prolong the whole case and bring it within the ambit of limitation. That's not permissible, my lord, in view of your lordship judgment. Kindly see Kamala Engineering, my lord. Lord, my compilation of judgments, page 175.
Yes.
Kindly see para 17, last paragraph of this page. Your lordship has decided this matter.
Yes.
And your lordship, she Bidra Dole also. Lord, question of limitation, your lordship has referred to in lot many judgments with regard to Lord Bidra Doria. Lord, before that, the compilation, page 2, man. Kindly see the identical situation arose here. Page 2, Vishram Bharu, para 11. Are your lordship?
Yes.
Lord, para 11. May be permitted to place it, Lord.
Yes, yes.
At the outset, it is required to be noted that the present case work order was issued on 7/4/1982 and the work excess work was completed in the year 1986. Even as per the statement of claim, the amount due and payable was under work order dated 7/4/82, which was executed up to 11/5/86, and work order dated so-and-so, which was executed up to 26/8/85. Therefore, right to claim the amount due and payable, if any, can be said to have accrued in the year 1985-86. That thereafter, under correspondence of RTI Act, had taken from 2012 onwards. Thereafter, for the first time, the appellant served a legal notice upon the General Manager, Southeastern Railway, on 22nd October 2018, either to release the amount which was overdue or to refer the dispute to the arbitrator under clauses 63, 64 of the GCC of 1996 Act. The aforesaid legal notice thereafter followed by 3 of our letters, communications, and thereafter the appellant herein filed present application 11-6 of 1996 Act before the High Court in the year 2029. Merely because the claim alleged dues of 85-86, the legal notice calling upon the respondent to pay the amount due, payable, or to refer the dispute to the arbitrator is made after a period of approximately 32 years, the appellant cannot be permitted to say that cause of action to file the application on 11-6-1996 has accrued in the year 2018-19. In the present case, legal notice has been served on the arbitration clause is invoked, and request to appoint the arbitrator was made after a period of approximately 32 years from the date of completion of the work. The appellant who served the legal notice invoking arbitration clause and requesting for appointment of an arbitrator after a period of approximately 32 years cannot contain that still his application under section 11-6 of 1996 Act be considered as the limitation would start from the date of serving legal notice, limitation would start from the date of serving legal notice and after completion of 30 years from the date of service of legal notice invoking arbitration clause. Then para 13. Therefore, in the facts and circumstances of the case narrated above, the High Court has not committed error in dismissing the application 11-6-1996 on the ground barred by limitation and is a stale claim. We are in complete agreement with the view taken by the High Court. Next, you will see me, Lord, BSNL at page 32 of my compilation.
Yes.
At page 32 of my compilation on BSNL 2021 Supreme Court, para 47 and 48. It's only in the very limited category of cases where there is not even a vestige of doubt that the claim is explicit time bar or that the dispute is not arbitrable, that the court may decline to make a reference. However, if there is even a slightest doubt, the rule is to refer the dispute to arbitration. Otherwise, it would approach upon what is essentially a matter to be determined by the tribunal. Yes, what your lordship was saying, my lord. And similar view was also in Vidya Doya, my lord. Page 130, para 148, my lord. Now, in view of these judgments, my lord, lordship, see, when his cause of action in fact arose, you have handed over the site in the year 2005, and in the year 2004, you have been last paid out of 65 lakhs, 56 lakhs you have been paid. Thereafter, you are sitting for 17 years without taking any legal action with regard to realization of dues. That's the reason, my lord, I am trying to tell your lordship that this is explicit stale claim.
My lord, only I will I will drag a kind attention of this court to Annexure 5, sir.
Yes.
Opinion number 1 has expressed on the subject closure of contract and settlement for payment for the work construction shelter Singrapal in Puri district package number so and so. My lord, just first para, second para, third para.
Yes.
As per the representation of the contractor, the OSDMA has requested for submission to the executive engineer by this office letter number 1147 OSDMA 2010, my lord, 28/4/2010. Subsequently, the chief engineer of building PWD by his office letter number 1619 OSDMA 9/6/2010, and then OSDMA dated 28/3/2011. The EE concerned failed to submit the final bill, but till that it is pending. He himself is telling on 1st June 2021, my lord. And lastly, he is telling, but it is to, in the meantime, the scheme has been closed by the World Bank since long, which this organization is unable to pay the final bill and other dues. The work department may make necessary arrangement for the payment of above pending dues and closure of the contract of above work. My lord, kindly refer to Annexure 3 series 47, page 47. It is a order under RTI. My lord, the executive engineer, who is the statutory authority under RTI Act, he is himself making an order as per the order number first appellate authority. The contract of the project Cyclone Shelter Singapore under package number WCS PUR will be closed. That means in that period it was open. As per their statements, it will be closed, we issue completion certificate and initiation will be taken for submission of final bill to us for sanction by 30/4/2021. The disposal of case by junior engineer. Then next page, my lord. Annexure 4. On that basis, they issued the completion certificate on 5/7/2021, stating in the enclosure copy of the final bill and handed over documents 2 pages. Only they submitted the final bill on 5/7/2021. My lord.
Lord, may I submit just one line? I'll just cite your.
And second thing, my lord, excuse me. Second thing, they have made a specific statement where I have suppressed many things which is misleading the court. I have never suppressed anything before the court. Because my lord, here they have given just kindly see Odisha State Vigilance SP's report performance criminal case. Here they have stated there is a misappropriation of fund, misappropriation of bill, misappropriation of work executed by the persons who are alleged here. No one concerned in this particular matter. They have never stated me in the official letters that one vigilance case is going on. That's why you is in problem. Always they say you will be taken care, and once completion certificate comes from the concerned engineer, and he will once he recommends the bill, then only we can pay it. Otherwise we cannot. Because as such, sir, the completion certificate gives the authentication of testimony of the building. In that period, testimony will be certified.
All right.
Lord, let me just submit one sentence in reply, my lord. Page 176 of my compilation. Page 176 of my compilation. That's what your lordship has held. But referring to the order that under annexure 5, if your lordship sees, page 49, it's an order dated 1st of June 2021. It's a letter 1st of June 2021. The date of completion is of the year 2004. Now, 17 years thereafter, this letter has been issued. And what your lordship has been pleased to hold is this, page 176, para 18. Thus, in order to be valid and enforceable, an acknowledgement in writing must be given before expiration of the prescribed period of limitation. Kindly see.
No. The question here would be,
Right.
Has that limitation begun to run at all is the question.
Right.
See, in the scheme of things here, it appears that they paid the 6th bill, but the final bill was not paid. The final bill had to be raised by not him, by the executive engineer.
By him only, my lord.
No. That was that. Just come
Bills
to.
are submitted by the contractors, my lord.
No. The final bill, whichever, see, he submits a bill, but that final bill on the agency has to be given by the executive engineer. It's a routine. He will submit it to the executive engineer. The executive engineer in turn has to certify and give it to the OSDBA.
Yes.
The executive engineer has not done that. The executive engineer is saying till completion certificate is there, we cannot send this final bill. So he's stuck. He has no way to pursue his final bill till that completion certificate is issued. So limitation will not begin to run till this part is over.
In that case, your lord. Pass out.
Yeah, all right. You see, the present petition at 11(6) of the Arbitration Conciliation Act, 1996 bracket Act, has been filed seeking the appointment of an arbitrator to adjudicate the disputes between the parties arising out of the contract agreement dated 18 November 2002 between the petitioner and the opposite party, Orissa State Disaster Mitigation Authority, also known as the Orissa State Disaster Management Authority, bracket OSDMA. for construction of a cyclone shelter at Singarpal, Kakatpur block in Puri district. Paragraph. It is not in dispute that there is an arbitration clause in the said agreement. Stop. In terms of the preliminary counter affidavit filed by OSDMA, the contract commenced on 25th November 2002 and was actually completed on 30th September 2004 and was handed over by the contractor to the Cyclone Shelter Maintenance and Management Committee on 8th February 2005. Paragraph. It appears that an interim deviation was approved for rupees 65,81,291, out of which rupees 56,23,171 bracket up to the 6th RA bill bracket was paid to the contractor. Paragraph. The question then arose as regards the payment of the final bill of the contractor. Paragraph. The case of the petitioner is that he kept waiting for clearance of his final bill and had to seek information under the Right to Information Act 2005 bracket RTI Act, which he received on 9th April 2021. From the Office of the Executive Engineer, a communication was received under the RTI Act on 25th March 2021, informing that open final bill has not been paid due to wanting of sanction, final deviation, and EOT. Full stop. It was further noted that, open quotation, the completion certificate and handing over documents are not available, and any complaint regarding unsafe of the building is raised from any users of the buildings. Full stop, unquote. Paragraph. The order sheet of the appellate authority under the RTI Act noted that, quotation, as per order of first appellate authority, the contract of the project, open quotation, Cyclone Shelter Singarpal under package number WCS-PUR-2 OSDMA will be closed by issuing completion certificate, and initiation will be taken for submission of final bill to OSDMA for sanction by 30th April 2021 for disposal of the case by junior engineer Konarak section, unquote. Paragraph. It appears that thereafter, the completion certificate was in fact B bracket R&B Division Puri on 5th July 2021, enclosing the copy of the final bill. Paragraph. Counsel for the petitioner has also placed reliance on a communication dated 1st June 2021, addressed by the Managing Director of OSDMA to the Commissioner cum Secretary Works Department, Government of Orissa, pointing out that the concerned had failed to submit the final bill despite OSDMA's request, and that, open quotation, till date it is pending, unquote. There is a specific line in the letter which reads, open quotation, the Works Department may make necessary arrangement for payment of the above pending dues and closure of the contract of above work, unquote. Paragraph. It is on the above basis that the petitioner issued a notice on 30th March 2021, asking for the clearance of the long pending dues, followed by another letter dated 26th April 2021, seeking the appointment of an arbitrator. Paragraph. It is on the above basis, it is contended by Mr. Panda, learned counsel appearing for the petitioner, that this is not a time-barred claim and that the cause of action continued till such time the completion certificate and final bill was completion certificate issued and final bill forwarded on 5th July 2021. Paragraph. Mr. P.K. Rathore, learned counsel appearing for the OSMDA, sought to contend that this was on the face of it a time-barred claim, since the contractor had failed to seek a completion certificate in terms of clause 55 of the agreement soon after completion of the work and handing over of the project way back in 2004. Relying on the decisions in Vishram Varu versus Union of India, 2022 SEC Online SC 487, BSNL versus Nortel Networks Limited, 2021 5 SEC 738, Vidya Drolia versus Durga Trading Corporation, 2021 2 SEC 1, and Kamalakanta Engineering and Construction Limited, National Projects Construction Corporation Limited, AIR 2022 Orissa 45. He submitted that on the face of it, since it was a time-barred claim, this court would be justified in declining the prayer of the petitioner. Paragraph. The above submissions have been considered. To begin with, it must be noted that in the present case, the procedure under the agreement in question envisaged the executive having to clear the final bill and then forwarding the final bill to the OSDMA for payment. We'll stop. From the information obtained by the petitioner through the RTI Act, it appears that this entire exercise was in fact not completed.
Would I just like to interrupt? I'm sorry, Lord, I beg apology. But since your lordship is going to appoint,
so we leave it to the arbitrator to
that's
decide.
fine, Lord.
All right. All right.
that will prejudice the.
All right. It appears to this court that this is not a case where it can straightaway be concluded that the claim is totally time barred on the face of it. Full stop. The petitioner appears to have an arguable case as regards limitation. Full stop. To that extent, the decision cited by learned counsel for the petitioner appear to be distinguishable on facts. Nevertheless, the court is of the view that the contentions of both parties on the issue of limitation should be left open to be decided by the arbitrator in accordance with law, and therefore the court does not express any final view on that issue. With this clarification, the court appoints what is the claim now? 12 lakhs.
My lord, it will be around 1 with interest, because mandate contract
differential amount, final bill, as I have calculated, should be 10 lakhs. Whatever additional he raises, maybe 10 crores.
It is 12% interest
on that. What
on the contract mandates.
On that, what I'm suggesting, my lord, subject to your lordship permits, my lord, page 52. He himself has suggested 3 names. I agree for Mr. Santosh Kumar Patnaik. Number 1, he's a senior advocate, or Mr. Vijay Kumar Das, retired vice chairman of SAT. Whomsoever your lordship feels proper.
All right. Mr. Santosh Kumar Patnaik.
No issue.
He's a senior counsel.
Senior counsel.
Senior advocate.
My lord.
To act as a sole arbitrator to adjudicate with the claims.
My lord, subject to approval, my lords, I'm just pointing out some problems in the High Court rule and arbitration rule. Can I be permitted? My lord, section 11:10 is now omitted in the new amended act.
No, I don't know if they have notified it.
Not relevant for the purpose.
No, it is not.
There is some dispute on whether it's notified or not.
Yes,
You
yes.
better be careful because in the
Yes.
High Court Delhi, we found that when we started relying on it, some lawyers relied on this 11:10.
Yes.
Then we realized it was not notified. See, it has to be brought into operation. Amendment is one thing.
Yes.
Yes.
It has to be brought into operation from a certain date. Maybe it is not still brought in. You just check that, double
Yes,
check it.
yes. My lord, obliged.
Including the claims and counterclaims. And the arbitration will take place under the aegis of the arbitration center of the High Court. Right.
And item 2, just
Item
a
two,
few minutes back, my friend has served a bulky counter. I need rejoinder.
All right. Rejoinder we filed before the next date.
3 weeks after, let's.
All right. List on 18 November.
All
All right.
Item number 3. May I please, Lord's invocation letter, Millards at annex of 15 page.
I think notice is
Done. Railway is the party, Millards. Last occasion is sought for time for filing counter.
I know. Where is he? We just pass it over once.
Mr. Pari is there.
Mr. Padi, what happened? Counter. Unmute, sir.
For Union of India.
You know,
But this has been, my lord, Union of India,
yes,
this has been allotted to me today, my lord.
I say. All right. All right. Counsel for the respondent, opposite party seeks and is granted 4 weeks. Apply. Rejoinder for the next date. 25th November.
Item number 4.
No, we'll say, sorry, 2nd December, sir, 2nd December. All right.
Item 4, probably that National Law University. My lord, here, in fact, I'll be requesting for the second time I'm appearing, my lord, listed today. I'll be filing a short counter.
All right. At the request of Mr. Rathod, learned counsel appearing for the opposite party seeks and is granted 4 weeks time to file a reply.
Yes.
Rejoinder for the next date. December.
Item number 5. Your Lordship, yesterday we had served counter affidavit to the counsel for the petitioner. Your
We
Lordship.
didn't receive, but now they have sent a mail. I'll go through it, my lord, let's give some time. I'm for the petitioner, my lord. May I audible, my lord?
Yes. They want time for counter.
Yes.
No, Your Lordship, we have already solved them yesterday.
Because this counter is not on record here.
Yes, Your Lordship.
Rejoinder be filed. All right, rejoinder be
Yes,
filed
yes.
for the next
Yes.
date. List on 18th December. Right.
Obliged, my lord.
Obliged, Your Lordship.
Item number 6.
It has already been settled. I may
Settled.
counter.
All right. Counsel for the petitioner states that the disputes have been settled and he seeks leave to withdraw the petition. It is dismissed as withdrawn. All right.
Item number 7.
Item
May please,
item
Lord.
7, where for the opposite party, my lord, will file the counter, let's give some time.
Counter, he had taken time on the last occasion, 2 months.
Last chance. You say Mr. Padi seeks and is granted a last chance to file a reply within 4 weeks, rejoinder before the next date. Again on 18 December, sir. All right.
Item number 8. Item 8.
That's 8. I'm just ordering a similar order that has been passed in similar matter, the arbitration tribunal. What is the arbitration tribunal?
Correct.
Millards? Now, Millards, what I suggest, Millards, my learned friend and I had a chat. We were on 3 names. This is just Dr. A.K. Rath, because he's having only one arbitration now.
All right.
The doctor. Then
we'll appoint Justice Dr. A.K. Rath. With the consent of the parties, court appoints Dr. Justice A.K. Rath for this court as sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. Right.
Millards. Plus, the second matter is the same issue, same kind of issue, same kind of agreement. Much obliged.
Separate. 2 orders, same orders. Right.
Much obliged.
May I, sorry to interrupt, my lord, along with me, Mr. Kashyap, name is reflecting item 7.
All right.
Mr. Kashyap.
Right.
Specialist.
All the important direction existed, my lord, with a very short span of time.
Specialist, old matter, item number 1.
None appears. Dismissed for non-prosecution.
Item number 2. Your lordship, this matter has become infructuous.
All right. The matter is rendered infructuous. It is post of
Obliged.
research.
Item number 3.
None appears dismissed.
Item number 4.
Item number 4, I do not have the file. I'm seeking for a passover with a permission if I can look into the brief.
All right, pass over. Yes.
May be permitted to look into the brief. I do not have.
Yes,
the
yes,
brief.
yes, yes.
Item number 5.
None. And none appears dismissed. All right.
Item number 6.
6, my lord. In this case, the application under order 21 rule 103 that is challenging the order under 21 rule 97. At that time, my lord, in the shape of first appeal, this appeal has been filed. But by virtue of that new notification, my lord, that will go to district judge.
All right. Counsel for the appellate for this appeal with permission to seek other appropriate remedies in accordance with law.
My lord, it is so much, my lord, that is transferred to district judge, but all the first appeal by virtue of new notification that through court, my lord.
So you'll have to apply there for this execution.
Then your lordship, my lord, interim order is there.
If the appeal is filed not later than, if the appeal is filed in the concerned court of the learned district judge, not later than 12th December 2022, then the interim order passed by this court will continue till such time the said court passes appropriate interim order on an application by the appellate. All right. The appeal is disposed of as withdrawn with liberty as aforesaid. Right.
Specialist item number 7.
Might please your lordship, I'm on BC. My learned senior Mr. Samreshwar Mahanti has died in the meantime. His chamber is locked. Though this is a petition for appointment for a grant of letter of administration. Having only my word format on my computer, the notice issued. The petitioners had advanced a sum of 14 crores to one Purna Tripathi who died intestate.
Right.
And thereafter, we have filed this petition for appointment of an administrator so that the money can be realized. We have given the details of transfer of the amount.
You are there in the matter?
My lord, I am appearing for objector number C and D. And I have already filed my written statement denying assumptions as well as challenging the maintainability of the proceeding. This is an application on section 274 and 300 of the Indian Succession Act. In Odisha, the district judge are the competent authority for grant of a letter of administration.
I see.
So this is the concurrent jurisdiction lies with the learned district judge. This application is not maintainable.
I see.
Concurrent jurisdiction lies with the High Court. In our High Court also under chapter 14, the procedure is laid down for admission and issuance of notice for issue of letter.
Parallel jurisdiction. I think parallel jurisdiction has been given.
Yes. And
such an application lie when there is a will or there is a codicil. In this case, neither there is a will nor there is a codicil.
No, that's why letters of administration. He says if it is intestate, he's still entitled for letters of administration. Because he has claims, then that needs to be settled.
And it is about 14 crores.
What is the value of the estate? Any idea? What is the estate value?
Estate value, my lord, it will be about 15 crores, which I have given in my annexure.
No, but is it available?
Yes, those properties should.
No. Are they available or not? Nobody will have any idea, sir.
The main property for which we had advanced an amount of 14 crores, that is still available. That is as per my knowledge.
May I please, sir? So in this case, we have the opposite party number 1 and 2. So on behalf of Vijen Rai, sir, he has already, he is no more. So kindly, sir. Not expert, the advocate is no more.
Oh, the advocate is no more, is it? I see.
Advocate is expert.
All right, all round, I think that's thing. So
kindly be taken for 3 weeks after so that.
All right, at the request of counsel appearing for all the parties, list on 7 December. All right, before the roster bench. All right.
Obliged, sir.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed. Are you there? Yes.
My lord, can you pray for pass-over?
All right. 9.
Yes, ma'am.
All right.
Item number 10.
I see. You know what? In all this JCRLV, they are all jail criminal matters, no? So I think we'll have to ask for a report from the prison authority. In 8, wherever we've said 8, 10, 11, you say a report be called regarding current status of the prisoner from the concerned jail, from the superintendent of the concerned jail before the roster bench on 15 December. Meanwhile, in each of these matters, the Secretary Orissa High Court Legal Services Committee will assign to the petitioner a lawyer of not less than 10 years experience to appear on his behalf. The complete set of the paper books be handed over to the Secretary Orissa High Court Legal Services Committee to be handed over to such counsel, who will appear on the next date. The name of such counsel be indicated in the cause list.
Item 8, 9, 10, and 11. Fresh admission item number 12.
My lord, on behalf of Ms. Mahapatra, kindly be taken up next week. Today is her mother's death anniversary. My
All right, all right. At the request of counsel of the petitioner, list before the roster bench on 11 January.
interim order, my lord, is there.
Interim order to continue.
Obliged.
Item number 13.
None appears dismissed.
Item number 14.
None appears dismissed.
Item number 15.
My lord, I may be permitted to withdraw.
Counsel for the petitioner seeks leave to withdraw this petition. Dismisses withdraw.
Item number 16.
None appears dismissed.
Item number 17.
None appears dismissed. If there's a stay order, you say stay order is vacated. Information immediately be sent.
Item number 18.
This is a case wherein section 124A is involved, in view of the Supreme Court's interim direction to keep the same all proceedings in abeyance, my lord. So this
Then can go back to the trial court also.
Yes. It has not started. Commitment has not been done. Since
Yes, so anyway, it will be, I'm just saying the trial court is also bound by the Supreme Court judgment.
That's not one aspect.
Yeah.
Second aspect, cognizance has been taken without prior sanction, my lord. Under the EUP Act, where sanction is required, that's a precondition. And section 2 provides that an independent review be made. That has not been done and sanction has been taken. That's another point. So the entire proceeding goes, my lord. Cognizance order is at 51, page 51. That's one thing. And the third one, my lord, this is maliciously, the case has been instituted. He joined in a party of the ruling party.
No, 1 minute. Cognizance is taken under several sections.
Yes,
not just under 124
yes,
and 153.
124 is one of them. Yes.
So then
the
how will
other
it
section,
fail?
if the court proceeds, it will not be prejudiced to the client, the petitioner, my lord. The court can proceed. That's what the judgment said, Supreme Court said, my lord. If it is not prejudicial to the party, my lord, the court thinks it, then it may proceed, my lord. So, so far as 124 is concerned.
No, so that's only one of the offenses. There are so many other offenses.
Yes, other offenses.
147, 148,
yes,
120B.
But once this is, my lord, then if certainly if allowed to be stayed, my lord, allowed to remain as valid, my lord, then again he has to face the second trial. Suppose it will proceed except 124A, and subsequently the court came to hold that no, this is valid, my lord. Then
So
again,
it all depends on the outcome of the final proceedings.
yes,
of the Supreme Court.
that's why I say that let the proceeding be stayed.
No, so it can go back to the trial court with the order of the Supreme Court. You say there is a judge, there's an order. Now, where's the Supreme Court order?
Supreme Court order, my lord, 11.5. I've got soft copy, my lord. I've just verified in soft copy.
The date and the.
11/5.
I don't have.
11/5/2020.
In terms of the order dated 11/5/2022 of the Supreme Court of
Yes.
India in dash. All proceedings under section 124 capital A IPC have been kept in asked to be kept in abeyance.
Yes, ma'am.
Full stop. Paragraph, it will be open to the petitioner to bring to the notice of the trial court the above order of the Supreme Court. Full stop. It is seen that there is also an issue raised by the petitioner regarding absence of prior sanction for initiating prosecution under the above provision. Full stop. This point is also left open to be urged at the appropriate stage. Notice that it is section 124 capital A is only one of the provisions in respect of which cognizance is to be taken against the petitioner by the trial court. Full stop. It will be open to the trial court, therefore, to pass appropriate orders in accordance with law, keeping in view all of the above circumstances. Full stop. No further directions are called for. The petition is disposed of.
Commitment has not been done. It has not been with the trial court, my lord. It has been pending since 2013, my lord. The honorable court granted him bail, and thereafter it is still pending, my lord.
We heard anything for that. I've just disposed it off. All right.
Item 19.
Item 19, my lord, no instruction in the matter.
No instructions dismissed. All right.
Item number 20.
None appears dismissed.
Item number
That
21.
stay is located at 20.
Item number 21.
None appears dismissed.
Item number 22.
Stay is located at that one. 22, the memo is taken and record. Dismisses withdrawn. The interim order is vacated.
Item number 23.
None appears dismissed.
Item number 24.
None appears dismissed. The interim order is vacated.
Item number 25.
25, may I pray for 1 week adjournment? Because of allotment, they fled away, and in the meantime, case has registered under section 366. And I have challenged in this writ application for the order of the cognizance.
But I think time is already granted, no? Yes.
My lord,
1 minute.
obliged.
At the request of counsel, the petitioner. See, you already were asked to produce the marriage certificate way
Yes,
back
my
in
lord.
2016.
My lord, in the meantime, we'll furnish the marriage certificate, my lord.
Where did you furnish it?
No, he hasn't furnished it. He hasn't furnished.
You've not furnished it. Where have you furnished it, sir?
Marriage
You've not
certificate.
furnished the marriage certificate.
We'll furnish the marriage certificate. Till late, I have not furnished, my lord.
6 years have passed, sir.
My lord,
Whenever you get the marriage certificate, you show it to the trial court. That's the best.
no, my lord, they because they are leading their conjugal life in very peaceful in their locality, both opposite party number.
All that is fine, sir. You're given 6 years time to produce either certificate or a marriage certificate.
In the meantime, I will file marriage certificate.
You file it in the trial court.
No, my lord, because they will suffer again. They will suffer because
Why should nobody will suffer? You produce the marriage
Sorry, my
certificate,
lord,
you seek
because
discharge, that is the end of the matter.
petitioner before your lordship under section 482 CRPs. If they will go to trial court, they will suffer in their locality because their conjugal life will hamper, my lord. That's why I am praying for short adjournment. In the meantime, we will submit marriage
You
certificate.
said despite 6 years, nearly 6 years have been elapsed since the order dated 9 November 2016, directing counsel to the petitioner to produce the marriage certificate. He has not done so till date. He seeks for one more adjournment. As a last chance, list on
Obliged, my lord.
22nd November before the roster bench.
Obliged, my lord.
Item number 26.
Well, this is for quashing. Your lordship may permit me, I will raise the
All
point.
right. Permitting the petitioner to raise all pleas at the appropriate stage.
Item 27.
None appears dismissed.
Item number 28.
Item 28, I am on VC, my lords. No instruction, your lords.
No instructions dismissed.
Item number 29.
29, my lord, raise all the points at the time of framing judgment.
Sorry?
Permitted to raise all the points at the time of framing judgment.
Permitting the petitioner to raise all points at the time appropriate stage of the trial court.
Item number 30.
None appears dismissed.
Item number 31,
None appears dismissed.
item number 32,
None appears dismissed.
item number 33,
Lordship may be permitted with the liberty to raise all issues at the time of trial.
Yeah, permitted to withdraw with liberty to raise all issues at the time, appropriate stage in the trial court.
item number 34,
34 may please. In that case, my lordship, the present person challenging to question the of the FIR, my lordship, which the FIR has been annexed in annexed in 1/1, my lordship, under section 409, 109 and 468-34 of IPC and 7 of Essential Commodity Acts. In that case, the present the allegation against the present person is a misappropriation of PDS rights.
So there's no stay granted by now, investigation will be over.
Investigation will be open, but the 60, as per the allegations,
Granted by this court, sir. So there is been no stay
the
granted.
enforcement department has been squad has been seized.
No,
The
not. You
15
see-
quintals which has been within these 31 bags, which PDS rice has been carried out, but as per the 3 hostels has been there. That one has a category stated that 15 quintals is seized from the one hostel, but he has been stated that 63 bags and 31 quintals means that has been total. At that time, the enforcement squad has conducted raid, and that stated that the all 63 bags and 31 quintals is for the 3 hostels.
Present petition seeks the quashing of an FIR in Karanjia PS case number 142 of 2016. During the 6 years of pendency of the present petition, there has been no interim order granted by this court. By now, the investigation of the FIR should have been completed. Consequently, the court is not at this stage inclined to interfere, leaving it open to the petitioner to raise all pleas at the appropriate stage of the proceedings. The petition is disposed of.
Congratulations.
35,
Liberty may kindly given to raise all the
Or permitting the petitioner to raise all pleas at the appropriate stage.
item number 36,
None appears dismissed.
item number 37,
None appears dismissed.
item number 38,
May I please? My lord, petitioner before your lordship is now a government employee. At the time of occurrence, he was working as the my lord executive engineer, irrigation division.
Now he's retired.
No, my lord, at present, my lord, he's working as the chief.
Cannot be, sir. He cannot be working. He was 56 years in 2016.
Yes, my lord, 2016.
He was 56 years.
My lord, I have to obtain instruction whether he has retired or not. But here, my lord, is a case.
You have yourself said you were 56 in 2016.
Yes, my lord. Yes, I have written, my lord.
No question of getting instructions on that.
My lord, but on merit of the case, my lord, that I have challenged this, I have filed this application challenging the order of cognizance, in which, my lord, that annexure 2, I have annexed that order of the cognizance, that order dated 29/3/2016, in which, my lord, that PR under section 17A and 25T of the Industrial Dispute Act 1947 is received against the Executive Engineer Kendrapada, Irrigation Division Kendrapada, at present so and so Engineer Irrigation Division, from the office of the District Labor Officer Kendrapada, register cognizance under section 17A and 25T of the Industrial Dispute Act 1947 is taken against the executive engineer, against the present petitioner. So, my lord, what is the allegation against this present petitioner? That when this present petitioner was acted as an executive engineer, at that time, my lord, that the opposite party number 2 filed an order before the office of the executive engineer.
my lord, as per the prosecution case, my lord, as per the complaint case, which I have annexed in annexure 1, that this case arising out of a complaint case, that he did not publish the list of the candidate in his notice board. That is his only negligences of the present petitioner at that time. For that reason, my lord, that this case was registered, the complaint case was registered against the present petitioner, and then, my lord, the Lord and magistrate, without applying the judicial mind, my lord, and without, my lord, seeing the ingredient of the offenses, whether that gross illegalities or, my lord, wrong committed by this present petitioners, that he took the cognizance against the present petitioner. For that reason, my lord, challenging the order of cognizance, I have before your lordship. And if your lordship will kind of have a glance to the order that which has already been passed by the tribunal, that I have annexed in annexure 3 series, page 14, that last portions of the order and paragraph 2, that neither the order discloses the direction to the present petition to publish a list of the name of the candidate. My lord, there is no specific direction. So for that reason, my humble submission before your lordship, neither that this present petitioner is aware of the order that I have to publish the name of the beneficiaries in my notice board, in my official board, my lord. That my humble submission, he has not committed any mistake in pursuance to his duty, my lord. So that without applying the judicial mind, that the magistrate was take cognizance against this present petitioners, in which, my lord, I have no fault at all.
All right.
For that reason, I am before your lordship.
The quashing of an order dated 29 March 2016 passed by the SDJ Kendrapada in 2C CC number 25 2016, taking cognizance against the petitioner for the offences under sections.
Offences, my lord, under section 17
capital
capital
A, the
A
Industry
and
Disputes Act 1947 bracket Act, and section 25 capital T thereof paragraph. Having heard learned counsel for the petitioner, the court is not inclined to interfere at this stage. Nevertheless, it will be open to the petitioner to all pleas raised in the present petition and other pleas that the petitioner may have in accordance with law before the appropriate court in accordance with law. Right. The petition is disposed of.
Item number 39.
My lord, dismissed.
Yes.
My lord, dispose of.
Just dictate the order, sir.
Item 39.
Yes.
May I please, your lordship? After the case is closed after evidence, your lordship. So withdraw.
Counsel of the petitioner states the petition has become infructuous. It is disposed of as such. Interim order speaking.
Item number 40. 40, lordship, liberty may be granted. I will raise all my grounds during the framing of charge.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item 41.
Right. Permitting the none appears dismissed.
Item 42.
None appears dismissed.
Item number 43.
43, my lord, kindly dispose of this case with a liberty to approach
Right.
if any
Permitting-
cause of action and survive
All right.
in the meantime.
Permitting the petitioner to raise all pleas. All right.
Item 44.
None appears dismissed. Okay, the memos are taken on record. Dismisses withdrawn.
Item number 46.
None appears dismissed.
Item number 47.
My lord, item 47, 48, 49. On behalf of Mr. NK, I'll pray for a short adjournment. He has some medical emergency today.
There is
some medical emergency in his house, so pray for a short adjournment taken up.
All right. You see 47 to 49, counsel for the petitioner is stated to be in some difficulty today. List before the roster bench on 14 December.
Obliged.
Item number 50.
None appears dismissed.
Item 51.
None appears dismissed.
Item number 52.
May I please, your lordship? My lord, question cognizance order dated 7/12/2016, my lord, passed by the law James is Harsuguda, my lord. The offense under section 490, 506, 34 IPC and 4 DP Act, my lord. My lord, kindly see in the annexure 2, page 16, my lord. that the informant prior to the lodging of the present FIR has made allegation of domestic violence and filed a petition before the protection officer Jharsuguda, which was forwarded to the court of the SDGM Jharsuguda. The said petition was registered as city case number 5337 of 2010 of the court of SDGM Jharsuguda, my lord. And that in the said city case number 5337 of 2010, there is a Samidas is not the husband of informant, my lord. How is it made out of 498 of?
Anyway, permitting the petitioner to release all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
Item number 53.
Item 53, Lordship, no instruction.
No instructions dismissed.
Item 54.
Permitted to withdraw, Lordship.
Permitted to dismiss is withdrawn, interim order vacated.
Item number 55.
Permitted to withdraw. Permitted to withdrawn.
Item 56.
None appears dismissed.
Item number 57.
None appears dismissed.
Item 58.
Challenging the cognizance order on section 379 and 109 IPC, my lord. No allegation has been made against the petitioner, but cognizance has been taken mechanically by taking into the account the charge sheet as page 17, my lord. There is an allegation that the petitioner has only taken the rope and tarpaulin from the truck at the check gate, but not the truck. There is the allegation of theft of
Raise
truck.
all these please. It's all matter of evidence, sir.
My lord,
It's a matter of evidence.
my lord, I will raise all the aspect at the framing of charge.
Correct. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is
Only at the framing of charge, because
whatever,
charge-
sir, at the appropriate stage we have said, so it will be open to you. Yes.
Item 59.
None appears dismissed. Interim order is vacated.
Item number 60.
None appears dismissed. The interim order is vacated.
Item number 61.
None appears dismissed.
Item 62.
Number 62, the case is, vigilance case is languishing more than 35 years. I pray that a deadline may kindly be passed by your lordship for early disposal of the case.
All right. Early disposal of the suit.
Vigilance case, man.
Vigilance case.
Vigilance case.
Man.
All right.
It is
It
lingering.
will be permitting the petitioner to raise all appropriate pleas at the appropriate stage. Petition is disposed of. It will be open to the petitioner to request the trial court for expeditious disposal of the matter. All
Man, I have already requested the Lord trial court, my lord. Nothing has, notices are not being issued to
A
the.
copy of this order be sent to the concerned court for both. All right.
Item 63.
None appears dismissed.
Item
Interim order is
64.
vacated. None appears dismissed.
Item number 65.
Question of cognizance, I am permitted to raise the points.
Permit the petitioner to raise all pleas at the appropriate stage. All right.
Item 66.
Memo taken on record. Dismisses withdrawn, interim order is vacated.
66 and 67. For orders, item 68.
Delay of 13 days. Our main challenge is the claimant is not the class 1 legal heir, because your lordship kindly have a glance of claim
The
application.
Notice is delivered, returned undelivered with the postal remarks addressee left.
I may be permitted to take fresh notice, my lord.
All right. The petitioner will ascertain the correct present of respondents 1 and 2 and furnish it to the registry within 4 weeks. Thereafter, fresh notice returnable before the roster bench on 8th February.
Obligement.
Item number 69.
No instructions dismissed.
Item number 70.
My lord, this is an application to grant a further time to deposit the cost amount. By order dated 9/9/2022, my lord has directed to deposit the amount within 4 weeks. The petitioner is a old ailing lady, my lord.
It's all right. 3,000 rupees. You could have paid it yourself, sir.
Yes, sir.
3,000 is not a cost for which you should be asking for more time.
Within 1 week, I will deposit, my lord.
What is 3,000 rupees, sir? Why should you not deposit it instead of spending all this money, filing an application? It is a complete needless, totally needless to do this.
My lord, the petitioner could not able to deposit within 4 weeks because he is an old ailing lady.
Whatever, 3,000, even a lawyer, as a lawyer, you could have paid.
No, he deposited on 14/10, the court could not accept it. Okay. That's why he is filed
All right, the delay in,
application.
all right. Counsel for the petitioner states that the amount has been deposited in the trial court on 14th October 2022, whereas it had to be deposited on or before 8th October 2022. The delay in making the deposit is condoned. The application is disposed of. The trial court will now proceed as if the delay in making the deposit has been condoned. All right.
Item 71.
Permitted to raise the points before the court.
All right. Permit the petitioner to raise all the pleas at the appropriate stage.
At number 72.
None
73.
None appears dismissed.
At number 74.
My lord, on behalf of HN Mahapatra, item 74 and item 75. My knowledge senior health is illness. I pray for next week, my lord.
All right. Counsel for the petitioner stated be unwell. List before the roster bench on 19th December.
Okay,
Item 76.
May I please, Your Lordship? I have challenged the passing of the FIR, Your Lordship. The FIR has been registered for in 1cc case, Your Lordship. This is the entire transaction was a business transaction, and the finance was actually the complainant purchased certain machine from a proprietor's concern in which the petitioner is no way concerned. He was an employee. The proprietor is concerned from the Gurgaon, Your Lordship. The machine was delivered. It was financed through the bank. Bank deposited the money, and bank, after the verification, they disbursed the amount to the petitioners. No, to the concerned proprietary concern, Your Lordship.
Unless there is a compromise, this will become a matter of trial, sir.
No, my lord, this is simply a business. The machine has been delivered. Nothing remains. And the petitioner is no way. It was just like as he is an employee. Property concern.
Matter of trial, sir. It's a matter of trial.
My unnecessary, because he is coming from Gurgaon and all that. He has been suffered also. He has
always asked for exemption from personal appearance, sir. There's no difficulty in this.
My lord, otherwise, because it's a complaint case. Out of the complaint case, it is registered.
All right. You settle the matter, then it will all be over.
No, he is asking, the bank has given me the money.
Right.
After verification of that, I have delivered the machine. He's saying that he refund this much amount of money because he's trying to, he's saying that, okay, whatever money you received, he was, if I'll read the, some 2 paragraphs of the complaint petition, you will also understand the thing. You will also paragraph 8, if you also take that after a quotation was been received, a purchase order was given, and some advance money has been deposited in para 9. Thereafter, he says there's certain alteration. The final amount was 86 lakhs 45,000 something. Thereafter, he made an further advance of 10 lakhs. Thereafter, Your Lordship, the rest of the amount, that is 66 lakhs, has to be after the money machine has been delivered, the bank given to the proprietor concern. He received the money after it has been scrutinized by the bank's official also. Now he is asking that 27 lakhs you refund me because there is a change in the specification. How it's a purely a business transaction and nothing is a criminal in nature. 409 section has been registered.
All right. Permitting the petitioner to resolve, please, at the appropriate stage. The petition is disposed of. All right.
Item 77.
I want to not press this application.
Dismiss is not pressed. All right.
Item 78.
None appears dismissed.
79.
None appears dismissed.
Item number 80.
Not pressed. Not pressed, dismissed. All right.
Item 81.
None appears dismissed.
Item number 82.
None appears dismissed.
Item number 83.
None appears dismissed.
Item number 84.
Yes. My lord, this is an application for restoration.
All right. What's the main matter about?
Yes, my lord, main matter. there is an application for substitution also that your lordship will decide in the writ application.
All right.
My lord, here, a suit for specific performance of the contract was filed by the plaintiff. The plaintiff is before your lordship. My lord, during cross-examination, the DW1 appeared in the examination in chief. He was partly cross-examined. Thereafter, he did not choose to contest. I filed an application to expunge his entire cross-examination because the entire cross-examination was not over. A petition was filed. My lord may kindly turn to page 61 a moment. Order dated 12/8/2011 of the trial court.
Yes.
Learned counsel for both the parties are present. The petition dated such and such to expunge the evidence of DW1 is put along with objection. Heard the learned counsel, put up on 28/2011 for orders on this court. Thereafter, my lord, 28, your lordship will see order is not ready. As further clarification of point of law is required, clarity to the petition, hence put up for regarding further hearing. 12/9/2009, September being declared holiday, the record is put up. Learned counsel for both the parties are present, but counsel for the defendant orally makes submission for time, put up on such and such for hearing. Then 15/9, learned counsel for part present, the counsel can however praise for time for filing a petition to this subject. Third, time is allowed. On 29/11/11, learned counsel for the contesting party filed a respective hajra. However, none moves petition on repeated calls dismissed. My lord, here I was present. Hajra has been filed. We are present. He has posted for orders on the previous date. He should have heard the petition on merit. He could have rejected my petition on merit. There is no bar, man. But can he, after accepting my hajra, can he pass such an order? This is the only point in this writ application.
For the reason stated, the order dated 16th September 2022 is recalled, and writ petition 27749 of 2011 is restored to the file of the single judge. In separate order in the writ petition, say the matter is restored today by the order dated so and so in CMAPL so and so. The list before the roster bench to learn single judge on 6th December, interim order to continue.
The substitution may be allowed.
That they led a single judge.
All right, all right.
Right.
Item number 85. Lordship, may I please, Lordship? It's a
See, along with all pending applications restored to the file.
here, Lordship, I have filed a application for restoration. It was dismissed for non-prosecution on dated 8th of July 2022, Lordship.
What's the matter
The
about?
matter is, Lordship, two brothers, advocates at the local bar. There were some misunderstanding regarding a civil dispute. Accordingly, there was a FIR by the OP2 against the brother. And accordingly, the charge sheet was submitted on 307 other offences. And in the during pendency with the investigation, the matter was settled.
Settled, is it?
Yes, Lordship.
All right.
Settled.
So for the reason stated, the order is recalled and CRLMC 3626 of 2013 is restored to file. In the main CRLMC, you say an affidavit has been filed by opposite party number 2,
Flat 2,
stating that the disputes between the parties have been settled. This has not been disputed by anyone. As a result, GR case number 2304 of 2013, pending the court of the SDJ Mangul and all proceedings consequent thereto, I hereby quashed. The petition is disposed of.
Grateful, Lordship.
Specialist item 86.
None appears dismissed.
Item 87.
None appears dismissed.
87, my lord.
Oh.
The order of taking cognizance without obtaining sanction, and your lordship last occasion directed my learned senior
Yes.
to obtain instruction as
Yes,
to.
yes, Mr. Katke.
No instruction. Sorry, boss. One more chance.
Counsel, Mr. Katke and additional government advocate seeks one more opportunity for instructions in the current status of grant of sanction for prosecution. Interim order to continue list on 4th January.
Obliged.
Item number 88.
None appears dismissed. Stay is vacated.
Item number 89.
I am appearing for the petitioner in So this is based on the section 138 NI Act. If the Lordship will see the impugned order of cognizance, that is at page 8, my lord. Here what has happened, the check was dated of 2008, my lord, and the complaint case was filed in 2015 after 7 years. And the learned magistrate has without referring in that order sheet whether the delay was condoned or not, he has straight away taken cognizance and has issued the summons, my lord. Though there is a provision that the delay can be condoned, but not for 7 years, and there has to be a proper explanation or an observation in the impugned order, my lord, of cognizance. Page 8, your lordship may kindly see. The first line, it says, the case record is put for hearing on limitation. Then thereafter he goes on saying that the check is dated and there is a prima facie case, and doesn't deal anything about the delay part, my lord. And page 9, he clearly says that the checks are dated 21/1/2008 and 22nd January 2008. He takes cognizance on 13/2015, and the complaint was filed in 2015 as well.
All right. The it must none appears this service of
from the opposite.
What is this, sir? Clearly barred by time.
Lordship are direct.
Clearly barred by time, sir.
Yes.
You say the challenge in the present petition is to an order dated 13 February 2015 passed by the learned SJM Berampur in 1 CC number
130, my lord.
130 of 2015 under section 138 of the Negotiable Instruments Act 1882 (NI Act). Paragraph. The short point urged by the learned counsel for the petitioner, senior counsel for the petitioner, is that the complaint itself was time barred, and therefore cognizance could not have been taken of the offence against. Paragraph. A perusal of the order taking cognizance dated 13/2/2015. 13/7, is it? 13/2.
13/2, my lord, February
2015 reveals that the case record was put up on that date, open quotation, for hearing on limitation, unquote. The check was issued on 21/1/2008 and 22/1/2008, and the complaint was being filed more than 7 years later. Without examining this aspect, despite noticing that limitation was an issue, the trial court has proceeded to take cognizance. Paragraph. There is no counter affidavit filed in the present petition to counter any of the above facts. Counsel for the respondent is also unable to explain how cognizance could have been taken 7 years after the issuance of the check. On the face of it, the complaint appears to be time barred. Consequently, the court quashes 1 CC number 130 of 2015 and all proceedings consequent thereto. The petition is allowed in the above terms, no assessed costs.
Item number 90.
May I please, my lord? And I'm appearing by virtual mode, my lord.
Yes.
But over a trivial issue with 2015, the case was registered for minor offences. My lord, although in between, my lord, the deposition of OP number 2 is over, wherein he has stated that matter has been compromised. Your lordship may record my statement and may direct the trial to be completed within 3 months.
All right. Mr. Rajit Roy, learned counsel appearing for petitioner, says there is a compromise petition of the parties on dated 23rd December 2014. In the circumstances, he requests that a direction may be issued to the trial court to expeditiously conclude the proceedings in accordance with law.
Your lordship may observe that in between, the OP number 2 has also deposed before the trial court. The matter has been compromised because the compromise petition was disputed by the learned trial court, for which reason I have come before this honorable court.
He points out that opposite party number 2 has in the meanwhile informed the trial court that the matter has been compromised. Paragraph. Leaving it open to the trial court to proceed further in the matter in view of the above development, the court declines to interfere at this stage. Nevertheless, it will be open to the petitioner to request the trial court, petitioners to request the trial court to expedite the matter. The petition is disposed of.
May I request to complete the trial within a time frame, my lord?
I've just said to expedite. See, the time frame and all doesn't work because they've got a huge load of cases. So I'm permitting you to request the court for expeditious disposal. All right.
Item number 91.
None appears dismissed.
Item number 92.
Present petition is arising out of a matrimonial dispute, my lord. And the husband wife are residing, settling their dispute and residing jointly, my lord. And therefore he has appearing the opposing, in this case, file affidavit to quash the proceeding, my lord.
Where is that affidavit, sir?
Affidavit is not filed, my lord. Today I am happy.
Opposite party number 3, your husband. Opposite number 2 is my wife. And the opposite party number 3, your husband has appeared today. And since my wife is staying after the Rajkonika, I am staying at the next week I will file the compromise petition.
All right, counsel for the party seek time to file a compromise petition. List before the roster bench on 5th December.
Interim order, my lord.
Interim order to continue.
Item 93.
May it please, your lordship. My lord, I may be permitted to appear, your lordship.
Yes.
I am for the bidding, my lord. The petitioners herein challenges, your lordship, the order dated 27/1/2016, that is the order of taking cognizance and issuance of notice. That is on a protest petition, your lordship.
All right.
The petitioner challenges that the proceeding, your lordship, is a process. Very briefly, your lordship, I am submitting. The petitioner number 1 lodged an FIR, that is annexure 1. Now my FIR has been charge sheeted, your lordship, that is annexure 2. After 10 days of lodging my FIR, the complainant herein, who is opposite party number 2, lodged another FIR against me, that is annexure 3. That is, my FIR is on 25/11/2022, and the complainant opposite party number 2's FIR is 2/12/2012. That is 7-8 days. My FIR has been charge sheeted as per annexure 2, your lordship. My FIR has been charge sheeted. The FIR lodged by the complainant opposite party number 2 has been final reported as false case by the police. That is, your lordship, as per annexure 3. Now, after that has been finally reported under these backgrounds, the complainant made a protest petition to the final report that has been submitted.
But who's appearing for the other side? Here, nobody seems to be appearing.
Because, your lordship, because it is a false case that has been finally reported by police. Taking the 2 henchmen with whom I have got strong rivalry, he filed a protest petition. The London lower court, without examining.
Okay, none appears for the contesting respondents. Number 2, contesting respondent number 2. Although a counsel had entered appearance earlier.
Yes.
In the interest of justice, list before the roster bench on 6th December. Interim order to continue.
Obliged.
Item number 94.
None appears dismissed.
Item number 95.
None appears dismissed.
Item number 96.
In this case, the initially complaint case was filed, and kindly have a glance to the last page. On basis of the complaint petition, London SDGM Kotak sent the matter to the under section 156(3) to the concerned police station, Badambadi police station, and the contention of the petition is totally civil in nature. No, that is a violation of the agreement, the violation of the contract, which is not attracted the criminal activities. And
so that complainant is not served. So
my lord, complaint case as treated as FIR, and on basis of which FIR has been registered.
No, not before this court, sir.
My lord,
the notice to the complainant has been returned unserved. The endorsement address he left.
Thereafter, the opposite party number 2 left the place, and
so then all the more that nobody's going to appear in the trial court, so that will get over in no time. You say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Petition, will file objection. I will file a petition before the trial court.
No, we permitted to raise all pleas, sir. No problem.
Item 97.
Proceeding instituted by the wife, my lord, on the Protection of Women and Domestic Violence Act, my lord. She's being already paid maintenance under the section 24 of the New Marriage Act. In the meantime, the petitioner has also retired service, my lord. So still then,
unless there's a compromise, is difficult, sir. There's no compromise between the parties.
No,
So we'll permit you to raise all pleas, permitting the petitioner to raise all pleas at the appropriate stage in the trial court. All right.
okay.
Item 98.
Pardon, my lord, item number 90 and no,
Yes.
no instructions.
No instructions dismissed.
Item number 99.
Your lordship, no instructions. Your lordship may kindly grant liberty.
All right, permitting the petitioner to raise.
All right. Item number 100.
And I'm for the informant. I'm for the informant.
All right, none appears dismissed.
Item number 101.
My lord, on behalf of Ms. Mahapatra, but kindly
When is that
next
matter listed?
next week, my lord.
No, when was the other battery petition disposed?
Seventh, my lord.
7 December.
Yes.
All right. Counsel for the petitioner is stated to be in some difficulty. List before the roster bench
Interim order to continue, my lord.
on 7 December, interim order to continue.
Obliged.
Item number 102.
Item number 102.
Memo.
I have filed a memo. Let the case not placed to.
Dismissed is withdrawn. All right.
We are from petitioner.
Pastor matter, item number 4.
Item number 4. It's a application for execution of an order, annexure 2 statement of claim, my lord, annexure 2 of the brief. And it's an application under chapter 27 of the Odisha High Court rules for execution of order 28, my lord, 28 rule 1, which says that orders are also executable.
What is the order, sir?
Well, the order is at annexure 2, annexure 1, page 6.
But no notice is gone for 16 years now, sir.
Well,
Nobody's bothered, obviously.
Well, the state is the sole opposite party. The noting says SR is not made, stamp reporting is not made.
For the last 16 years, stamp reporting was not made of this press matter.
If your lordship permits, I'll serve a copy to the state. I'll only state at the opposite party. The claim is in the form of an order of attachment, 5,40,000.
Okay. Mr. Monty, you take notice of this. All right. Copy of the petition be served on the counsel of the state within 1 week.
Well,
for instructions to enable list before the roster bench on 29th November.
Obliged.
All right.
Supplementary list, old matter, item number 1.
My lord, this is a appeal filed by the state, but in fact, the delay is more than a year, my lord. But state has a good case, my lord. Here, my lord, the very induction of this respondents has been struck down by this honorable court.
No, notice is not gone yet.
No, my lord. On the question of delay, my lord, notice has.
All right, notice on delay.
Much obliged.
Returnable before the returnable, we'll have it on 12th December.
Much obliged.
All right.
Item number 2.
Okay. Yeah, all right. Yes. None appeared even on the previous date, none appears today. Dismissal of prosecution.
Appearance of error note that man.
Yes, yes, of course.
Item number 3.
I'm appearing for the appellant here in this case, my lord.
Yes.
For 12 days, a notice hasn't been sent as yet.
All right. Delay notice returnable 19 December.
Obliged, ma'am.
Right.
Item number 4.
Item number 4, if your lordship permit me, I will file a short note by next week, because here the service of the petitioner has not been allowed, though the single judge is allowed to, as per the judgment of this honorable court.
All right. You say counsel for the appellant seeks to file a note of submissions before the next date. List on
Next week, any date, manner, or
9 January. 9 January.
Before that, manner, at any date, because it is a case where the petitioner is not in job now, because on the last year he has been.
All right, 5th December. 5th December.
5th December. Okay.
Supplementary item number 5.
My lord, in this case, the petitioners are the villagers of village Potapakari have challenged the enforcement by private opposite parties numbers 6 and 7. There is a notice has been served, no report. That is the land recorded in the favor of Cuttack Municipal Corporation with non-jurisdiction.
No reply has been filed, Mr. Manti.
None has appeared even. None has appeared even.
For the private opposite party, I am appearing.
State has to file a reply. Mr. D.K. Manti, learned additional government advocate, states that reply will be filed within 4 weeks, rejoined for the next date. It's noted, you appear for the private opposite parties.
Yes.
Your reply?
No, my lord, I have not filed, I have not obtained the present status of the land.
All right. Counsel for the private opposite parties also states that he'll seek instructions and file a reply within the same period. Rejoinder before the next date. 10th January. Namaskar.
May supplementaries for orders, item number 1.
May I please your lordship?
Yes.
I have no grievance with the order passed, but my predicament is in view of this order, though the lordship will kindly turn to the petition at paragraph 2. They had filed a writ application challenging the allotment of the tender work to non-DGR sponsored agencies. Because DGR refused to work. If your lordship will kindly turn to the annexure 1, I have filed, my lords. Annexure 2, kindly see at page 24, the letter by DGR sponsored union. Therefore, following actions are requested. MCL can engage non-DGR security agency in case of non-ability of ESM to provide security cover. Page 24. The
Yes.
DGR wages which are being paid to unauthorized non-ESM civilian guards in the garb of security cover being provided from DGR empaneled security agency to be stopped with immediate effect to prevent financial loss to the exchequer. The DGR wrote to us. Thereafter, we have appointed a non-DGR agency, SIS. The union had filed a writ application challenging the employment of non-DGR employees. On this, Honorable Court rightly disposed of the writ application to raise their dispute, but the observation in the application, my lords, para 4,
Yes.
that regard being had to the provisions contained in 33 of the, we dispose of the writ petition, directing the Assistant Labour Commissioner on good, that is conciliation officer, to proceed conciliation without affecting service condition. Taking this line, they are totally obstructing our work, saying that unless you pay DGR salary, we will not allow the MCL to continue with the work. That is our difficulty. I am only praying, let them, your lordship may correct it to say, as per the contract, we will be paying them. We have entered into a contract to an organization called SIS. He is supplying the labor. The DGR themselves have said, we are not getting DGR empaneled personnel. Don't engage the DGR sponsored union. And you are facing loss. That is the difficulty.
But this is a matter of arguing before that court, sir.
Exactly.
How this should be interpreted will be up to that court. You argue and that court can be, taking a call one way or the other on your argument. We should not be further explaining our own order. But that's not a review. That's not the function of a review petition anyway.
Then I will file an, the lordship may permit me to approach this honorable court by way of a writ application.
Another round.
Whole difficult, my work is being stalled, my lords.
But that whatever that court decides, that you can challenge. If it's adverse to you, you challenge that order of that court.
Conciliation officer's order.
Whatever. We don't know. We're not here to give free legal advice. So
Your lordship may permit me to challenge the appropriate order.
no, counsel for the learned senior counsel petitioner seeks leave to withdraw the review petition with liberty to seek appropriate remedies as may be available to the petitioner in accordance with law.
Obliged, obliged. Number 3, my lord.
All right. This post of is withdrawn with liberty is grateful.
Delay, some delays that should be controlled.
Yes, your lordship may condone.
Delay condoned. All right.
Obliged.
Item number 2.
For bail, IA 222.
Yes, bail application for another accused.
Right.
We had earlier released the main accused against whom direct allegations have been made.
Right.
But this petitioner, some allegations have been made, but there is no direct allegation. But
and he has spent 11 years in jail, sir.
Exactly, and that's what I mean. And he has spent 11 years in jail.
All right.
Where is the petition?
Put down the name of the counsel. You say it is seen that the present appellant has spent more than 11 years in jail. The co-accused has already been indulged in bail by this court. It's unlikely that the appeal will be listed in its turn in the immediate future. Full stop. In the circumstances, the court directs that the appellant number 2 / applicant be enlarged on bail during the pendency of the present appeal, subject to the satisfaction of the trial court. The application is disposed of. Right. Right.
Sir, Pranam.
Pranam, sir. Pranam.
Supplementary list for orders, item number 1.
Inadvertently typed, you say that correction be carried out as pointed out by the registry. Right.
Item number 2.
Item number 2, senior advocate Mr. Vaidas is appearing in this case and he is not aware. So I pray kindly annotate.
All right, Mr. Yashovan Das, learned senior counsel for the applicant. This is an IA 18845 of 2021, right? Is stated to be unwell. List on 16th.
Okay.
Item number 3.
What's the delay?
My lord, I'm sorry. Can your lordships hear me? In item number 2,
Item 2, yes.
they have not paid the 17B wages as on date in spite of a specific order. Now they file an application here. Your lordship may list this matter within on 26th or the 27th.
No, it has only to be on a Friday. We are a special bench.
Can it be on the 9th of December?
We can keep it because he's unwell. Not sure how that's why. We've kept it for
Almost after 2 weeks.
all right. 18th. Okay, we'll keep it for 25th November. We'll keep it for 25th November. All right.
I may be pardoned. Item 1. Item 1, I am appearing for the opposite party.
No, we're just carrying out the correction. That's all. The registry has pointed out some corrections. That's all. Right.
Last occasion, your lordship, I also absent. Though I am present here.
All right. All right.
Your lordship, my appearance may be-
All right. His appearance. You please put down in a piece of paper your name.
Item number 3.
With leave of your lordship, my lords. I'm seeking your lordship's kind indulgence for review of your lordship's order, my lords.
Yes.
If I'm permitted to take a minute from your lordships, my lords. The order which we pray before your lordships to get it reviewed, my lords, is there before your lordship, but there's 2 of my review application.
Yes.
And your lordship are pleased to take note of our all submissions. But I would only beg that this is relating to encroachment of a crematorium ground of 4 villages, and that your lordship has taken note of that. But there has been an observation that we must go to the civil courts.
Correct.
My lords. My only submission before lordship is the determination, identification of those encroachers are admitted by the government by itself.
But not by the encroachers themselves. See, there's a whole difficulty is it's a tripartite dispute. If it is a dispute only with the state and you yourself, it's one thing.
Yes.
Since you're alleging some people are encroachers, they will obviously have a say in the matter.
True, man. But my only submission before lordship is that those encroachers have been found out by the state government revenue authorities to be encroachers.
Right.
And they do not come before your lordship. And the judgment, I will only beg your lordships to kindly peruse a document.
All right.
That was not placed before when the application was disposed of by your lordship.
Right.
That document is at page 23, white annexure 1 to the review application. There, it indicates that the state government authorities have taken note of the presence of encroachers as well as the villagers vis-a-vis the state government authorities, my lords. There they have taken a decision that the encroachment over the recorded that is the cremation ground, land will be evicted as early as possible. And these, or there are number 4 to 5 decisions that are taken by the authorities, my lords. If the encroachers are otherwise homesteadless and eligible for government land settlement, their case for allotment of land under OGLS rule will be taken up separately. And the ADM, Additional District Magistrate Khordha, instructed Tahsildar Tangi to be watchful to prevent any further construction over plot number 88 and 18 under Khata number such and such in Mauja such and such. We are only concerned, there are a number of encroachments that we are not concerned or worried, my lords. We are only concerned about this plot number 88 and 89, where the encroachers, they do admit that we have been encroaching. The state government authorities, they say that there has to be steps to evict them. And my lords, with leave of your lordships, subject to your lordships' approval, a judgment in the regard with regard to encroachment of all these areas in different states were taken up by the Honorable Apex Court, my lord. Your lordship, I'm pleased to record, but there has been a direction. If I am permitted to give a copy of your lord, the judgment to your lordship's board,
Yes.
If your lordship permits me, I would take the lordships only to page 401.
Para 23.
Para 23, my lord.
Yes.
I need not, if your lordship stated so.
Yes, yes.
That para 23, if only I seek leave of your lordships to, in my anxiety to read it again, my lords, if your lordship so pleases. Before parting with this case, we give directions to all the state governments in the country that they should prepare schemes for eviction of illegal occupants of the Gram Sabha, Gram Panchayat, Parambok, Shamlat land, and these must be restored to the Gram Sabha, Gram Panchayat for the common use of villagers of the village. For the purpose, the chief secretaries of all state government union territories in India are directed to do the needful, taking the help of other senior officers of the governments. The said scheme would provide for the speedy eviction of the such illegal occupant after giving them a so-cause notice and a brief hearing. Long duration of such illegal occupation or huge expenditure in making thereon on political connections must not be treated as a justification for condoning this illegal act or for regularizing the illegal possession. Regularization should only be permitted in exceptional cases, example, where lease has been granted under some government notifications to landless laborers or members of the scheduled caste or scheduled tribes, or where there is already a school, dispensary, or other public utility on the land. Let a copy of this order be sent to all the chief secretaries of all states and union territories in India, who will ensure strict and prompt compliance with the order and submit compliance reports to this time. Although we have dismissed this appeal, it shall be listed before this honorable court from time to time on date fixed by us, so that we can monitor implementation of our directions herein. Such and such, my lord. And pursuant to this judgment, the state government authorities have also framed a modality. My only submission before lordship would be subject to your lordship's acceptance and approval. Since we are seeking a review, your lordship may only grant us the liberty to approach the authorities by stating these issues so that they can take appropriate steps as per the frame out or the policies they have themselves done.
Not. We're not inclined. No grounds made out for review. The review petition is dismissed. Right.
Item number 4.
Grateful, man.
May I please, your lordship? In item 4, your lordship, I have had an application for restoration of my writ petition, which was dismissed on for non-prosecution on 12th of August 2021.
All right. For the reason stated, the application is allowed. The order dated 12th August 2021 is recalled, and writ petition 14060 of 2018 is restored to the file of the roster list on in that separate writ petition. Say today it's been restored. List on 12th January.
Grateful, your lordship.
Item number 5.
May I please, your lordship? I filed a same appeal petition for restoration of
writ petition, your lordship dismissed for default on the order dated 13/8/2021, my lord.
What's the main matter about?
Main matter about, my lord, this is challenging the SAT order, State Administrative Tribunal order, my lord.
Okay. All right. For the reason stated, it's restored again the same order. Let's move for the roster bench. On 7 number.
Oblige, your lordship.
Item number 6.
6, my lord, that was dismissed for non-prosecution on 7/10/2021. I have filed a restoration application. You
All
also
right.
directed me to file an affidavit. Noting is that I have not filed, but I have filed this affidavit since additional affidavit 14/3/2022.
I see. All right.
The present.
For the reason stated there. Where is it? 17 January 2024. Ah. One 10674.
There, your lordship directed to file an additional affidavit to the present.
Oh, I see.
Status.
All right. An additional affidavit has been filed.
14/3/2020.
All right. The reason state, and the additional affidavit has been filed today in court. Paragraph, the reason stated therein, the application is allowed. The order dated 7/10/2021 is recalled, and the petition 10674 of 2014 is restored to file. We are listed before the roster bench on 20th December.
Obligations.
Or
Interim order to continue.
no, soil. Namaskar.
Supplementary list fresh admission item number 1.
May it please your lordship. My lord, the statutory appeal has been dismissed at the stage of admission. The moment I started making my submission, Madam Justice Pandya started dictating the order by seeing the impugned order only. Impugned order has been reiterated. My lord, the matter, it owes its origin from the Hindu Marriage Act, only one appeal. The right of appeal is to be admitted, thereafter calling for the LCR, it is to be decided. My lord, your lordship may kindly see page 14. Page 14 of the dismissal order by this honorable court, my lord. Here, my lord, this court went through this is the finding. This court went through the impugned order minutely. This court is of the opinion that the learned court below have discussed the threadbare to the evidence adduced by the parties and made the analysis of the facts and case laws in detail. There is no evidence which will be reliable. My lord, there was no evidence before the court except the impugned order. My lord, previously these are first appeal is listed before the registrar, except the stay matter limitation, it was listed before the honorable bench. It was being admitted as a routine matter, thereafter LCR called for, it was to be decided. This is that first appeal, my lord, before the honorable bench, my lord. My lord, without hearing me, my lord, with all respect, I would say, my lord, it is dismissed at the stage of admission, my lord. My lord, when the husband is suffering because the wife did not cooperate for consummation, my lord, that itself amounts to 2002. Then that, my lord, says separately. All the things have not been examined. Only the impugned order has been quoted, my lord. This way, my lord, it has been dictated. This way, I would submit before the lordship, my lord. If my lord.
No, what has happened after order was passed quite some time ago.
Order, then I filed the review, my lord. Then I filed the review application immediately within time.
No, you are not together.
My lord,
you are not together. The husband and wife are not together even now.
No, 2002 beyond, and that is the finding. But irretrievable marriage, that is not the ground. That itself amount to mental cruelty. It is the finding that beyond 2002, outside, there is no possibility of doing that is also there.
What will happen to me, my lord, everything, my lord, kindly see. I am giving maintenance, everything. Thereafter, I am, my lord, if there is no chance of reunion, my lord, so diversion will be granted.
Justice Panigrahi,
Yes, sir.
one possibility is that we send them for mediation. We'll issue notice and then if she comes.
That we can, yeah, that we can do. Yes.
You just say notice returnable.
My lord, obliged.
9th December. All right.
My lord, obliged.
Right.
For issuance of notice, may I deposit anything or?
Yeah, no, normally whatever has to be.
Yes, obliged.
My lord,
Ha.
namaste.
Namaste. So the first item, he's Mr. Ishwar Mohanty is here. He says he needs 1 week to ensure compliance.
Yes, my lord.
All right. At the request of Mr. Ishwar Mohanty, Learned Additional Standing Counsel, who seeks a week's time to ensure compliance. List on 11th November.
Grateful.
Item number 2.
So today there's no time.
No time, my lords. More than I know, your lordship has a very busy schedule.
Today.
Yes, yes. Every day your lordship is
No, I
having a
know.
busy schedule.
Today we have a reference and all of
No,
that.
I'll just take, today I have received the objection.
Huh.
I'll just point out how bereft of merit is the objection is.
No, can you point out next week?
Sure. Whatever falls from your lordship's lip, I am bound to obey.
All right.
Okay. All right.
All right.
It is
So
my,
list on 4th November, sir. 4th November. All right.
as your lordship.
Number, Lord, along with Mr. Prabhupada,
Yes, yes. Over.